As I mentioned, I'll just briefly make the introductions again. My name is Divij Joshi. I'm a lawyer and an independent researcher. I also contribute and edit to the Spicy IP blog. And I'm really interested in questions primarily around how archival practice relates to the law. It's a question that hasn't been, at least in my research, hasn't been significantly considered under Indian law and policy. And I definitely think it's important for everybody on this call, everybody watching, and everybody who's interested in this topic to start maybe thinking about this and what implications it has for archival practice, what implications it has for the work that archives do and the kind of public the role that they play in the public interest as well. I wanted to start off the session, and I know we're a little late, so we'll cut down some of our time that we've spent discussing, but I'd love to have this be very conversational and not as a lecture. So I'll just briefly start off with some of the considerations under the law, which I think implicate archives or which archivists should be concerned with. And we have two great panelists with us, or discussants with us as well. There's Anubha Sinha from the Center for Internet and Society, and Srinivas Kodali, who's an independent technology researcher and policy researcher. And I'll let them introduce themselves in more detail. Anubha?
Thanks, Divij. Hello, everyone. I'm Anubha. I work at the Center for Internet and Society. I started off as an IP researcher back in 2017, along with my colleagues Shumandro and Sinha. We conducted a field survey of 4 Indian archives. The objective was to sort of prepare a legal guide for archivists, specifically related to copyright matters. So I will be primarily drawing from that experience, and otherwise I study various other issues relating to tech and society at CIS. Thank you.
Thank you. Srinivas?
Hi, everyone. I'm an interdisciplinary researcher. I've been primarily into the whole archiving space because I was trying to archive a lot of public data and documents. In this talk, we're going to mostly look at some of my work in the space. It's mostly experiments. I primarily look into the whole space of digital archiving.
Great. Thank you. So, yeah, as we just had an experience, I think for many reasons, thinking about the privacy dimensions of all of our work is really important. Maybe not just on Zoom calls, but also in the context of all of the records that people have been curating, the kind of preservation and access work that archives do, right? And for the purpose of this discussion, I wanted to, there's a lot of laws that relate to documents, right? And or documents or records or preservation of any kind of historical material. It can range from, any kind of law that implicates speech or communication, like defamation, or company laws which deal with company records. But we're going to limit ourselves for this discussion to copyright law and to privacy law. Both are highly contested fields, particularly in the space of, because nothing is ever fixed in the law, and as any lawyer will tell you, everything depends. But I think that these two fields particularly have very significant implications already, and particularly in the context of developing regulations for archival practice, and something that everybody needs to kind of keep in mind when going about their work. And particularly, I think the public also needs to keep in mind what implications the development of these laws has for the public interest and for archival practice. So to begin with, I'll just give a very brief introduction of copyright law. And these are all issues, I think, definitely archivists, archival practitioners, historians, and people who are interested in this subject have already thought about, right? How does attribution work? What are the kind of like ethical and moral dimensions of attributing a form of work to someone and giving them kind of, ownership of, or allowing them to own that kind of any kind of work or claim authorship of it. And that's the field of law, and that's the field that the law of copyright also intends to regulate, right? So it very broadly exists to enable authorship claims over any kind of work. This work can be, it can be film, it can be photograph, it can be literary, dramatic, it can even be simply a performance. Copyright, now the idea has historically been to kind of balance access to all of this important creations and works that people make, or creative works that people make, with kind of incentives to maybe produce more of this work, right? Or kind of other moral claims that individuals may have over authorship. In India, we mostly talk about copyright through, the statutory confines of the Copyright Act of 1957. And this kind of gives a very, I think anybody just reading through the act may not have a very good idea of what it means, because I'll just give a sample from what it says. One section which is particularly important for archivists, and you can tell me if you understand a lot of it, because I certainly don't. So section 52(1)(p) of the Copyright Act states that the reproduction for the purpose of research or private study, or with a view to publication of an unpublished literary, dramatic, or musical work kept in a library, museum, or other institution to which the public has access, is not considered infringement of copyright. Then there's like a 4-sentence long proviso about the specific conditions required to fulfill this. And the problem is that things like library, archive, museum are not defined under copyright law. These are not institutions that the law recognizes through a fixed definition, or particularly recognizes through regulation. So it's kind of unclear what status archives have under copyright law, which also means that it's unclear what kind of rights they have to make unpublished or published material available, to actually exploit exceptions that we have in the public interest for copyright to actually go about doing their work. There are a few interesting concepts around how copyright law functions, which particularly implicate, I think, archival work. The first thing that's really important to understand is that copyright is always presumptive. So you don't need to register a copyright in order for anyone to have an authorship claim over a particular work. So if I take a photograph, and as long as it fulfills a very basic degree of creativity and originality, that's the standard test that's applied, at least in India. If it's even like very basically creative, or it has, if I put in even some amount of like a very minimum amount of work into making that work, whether it's a movie or whether it's a photograph or some kind of poem or any kind of literary work, it's presumed that I have copyright over it. I don't need to register it. I don't need to tell anybody about it. Whether or not I publish it, or whether even if it's not published or made available to the public in such a way, it would be considered that I have copyright claims over it. And this is kind of the presumptive nature of international copyright in general, right? So yeah, and I think one important thing that may not immediately occur to people is that copyright exists even in unpublished works for that particular reason. Now, archives deal to a large extent with unpublished works, as opposed to, say, a library, which deals primarily with published books and published records which have been made available to the public. Now, the copyright law in India does very specifically cover unpublished works. We know this much, but we don't really know what constitutes publication. That's one of the big kind of lacunas in the Indian law, where we don't know when something shifts its status from being a published work to an unpublished work, which is important because the degree of regulation over different kinds of works depends on its status as being published or unpublished. And this has kind of like been a big problem under Indian law, and when we try to consider the status of a work and what kind of regulation we ought to apply to it. I would say that when you're trying to define whether something is published or unpublished for the context of a copyright regulation, it's important to mostly look at the intent through which that was made public. So you can say share it with a group of editors or a group of people to review a particular manuscript or a draft, but it still may not constitute publication. This becomes important, especially considering some of the exceptions that I'll come to, where unpublished works actually are granted some, sometimes additional protections, but sometimes additional exceptions, particularly for archivists to use. Right. So what kind of rights does copyright grant under the statute particularly, right? And I think this is also important to see what are the limits of, what an archive, what archival practitioners do in relation to records, and what rights of others they may be implicating. right? So the first and foremost right, I think, is, as it says, the right to make copies, right? So simply copying any kind of record is a right that's granted usually solely to the author of a work. Within that right, of course, is, and a very related right, is the right to distribute those copies. So both the act of reproduction as well as the act of distribution of those reproduced copies has an element of a copyright that's granted to the original author of that work. There's also the right to communicate that work to the public, right? The right to, for example, read out from a book, or make a book, turn a book into a play or something like that, to kind of have that work not necessarily distributed, but simply communicated in one form to the general public. And similarly, there are, rights to have that work adapted in a different form. And I think this is also particularly important because a lot of the work archives do is to place certain documents in a different context from which it may have originally been kind of procured, or may have originally been granted to the archive. And that context is really important because it gives a very different flavor to what that document could mean, or what that record could mean. And that in some, in some understandings of copyright law, placing a document in a very different context from which it was originally procured could also mean that this is not considered a distribution necessarily, but it's considered an adaptation almost. And I think, there have been a lot of kind of legal cases around, for example, how Google, the search engine, operates, right? So when it makes images available in thumbnail formats for everybody to kind of view and access simply as a search engine function, it changes the context of how that image is seen under the law, right? So that's kind of, it makes an adaptation of that image in a different format, and therefore the kind of copyright implications of that also change accordingly. Right. So once we know that, a lot of the records that archives deal with are presumptively copyrighted, you can assume that a lot of the unpublished material, correspondence, audio-visual files, oral histories can presumptively be said to belong to someone, or someone or the other will usually have authorship claims over it, right? Particularly, basically, any original medium that's fixed in a tangible form will usually kind of have some form of copyright claim over it. So what kind of legal permissions exist to actually ensure that these copyright claims are, or the use of this presumptively copyrighted material is legal or is fair, right? This is obviously important for a number of reasons. One of the reasons is that, everybody is kind of risk averse. Nobody wants to have a sudden lawsuit coming out of nowhere from someone claiming authorship and then getting sued. Even though it may be rare, it's simply, I think, good practice to be risk averse and understand the potential copyright implications of the work you're doing. But also to kind of, because copyright law and policy ultimately affects the ways in which we start sharing knowledge, the ways in which we start thinking about different forms of access to records, access to history, and access to knowledge. It's important to keep in mind that the things you're doing, are built, there's a systemic focus towards how archives are conducting their work, right? And if that system is wrong, then there needs to be also concurrently an effort to change the kind of policy and law that archives have to deal with to make sure that, that the whole system is functioning in a smooth and well-regulated manner. So I would say that there are three primary ways in which the archives can deal with procuring copyrighted material and ensuring that it is legally used. The first, of course, is something that you're all likely aware of, is through the agreements from which you source all of your records, right? So donor agreements and licenses. These are all, parts of kind of, these work under the framework of contract law. Contract law very broadly exists as voluntary arrangements with particular restrictions. So the rights that archives have under the law cannot be contracted, more like possibly cannot be contracted out simply through a donor agreement. However, the rights that authors or owners of a work have they can be contracted out. So they can say that I, don't want any claims over the kind of material that I've published or that I have authorship rights over, and I'm going to sign these over entirely to the archive that I'm donating them to. The language is really, really important when you're looking at these donor agreements in terms of what exactly they're signing out to you. It can be there are generally two forms of how copyright is given to archives or given to any institution. One can be a license, right? And a license is not the signing over of the entire copyright, but signing over certain parts of, the different rights within a work that I just explained to you. For example, the right to distribution or the right to reproduction, and that's contained within a license. An assignment, on the other hand, is a contract where all of the kind of entire bundle of rights that a copyright assumes is handed over to the person who is the assignee. So these different kinds of contracts are generally important to keep in mind. Secondly, there are like statutory mechanisms such as compulsory licensing. And this, I think Anubha can speak more to when she gets to her part, but India does have a mechanism where you can apply to the government to say that I'm unable to find the author of this work, or perhaps the author is dead and I don't know how to secure this kind of license. So take this fee and please let me use this work as a compulsory licensee of this work. So this particularly applies to the concept of orphan works, what are known in copyright law as orphan works, which are works which don't have a clear author. And I think archives particularly work to a large degree with orphan works, and there's something called the orphan works paradox as well, which is basically that, the less kind of financial incentive that the less financial value that something has, a particular work has, the more difficult it is to find the author for that work. Right. And given that we have presumptive copyright law and that it's always important to assume that kind of a work has an author who may have a copyright claim over it, it's kind of important to, it makes it incredibly difficult to find, owners of copyrighted work who aren't particularly interested in it, right? So there may be some form of some form of correspondence from 50 years ago, which could have a living author who can potentially claim copyright over it, but the law necessarily requires you to take permission from them, even if they don't want to monetize it, even if they don't care about that particular publication. It's always kind of like this strange risk that you're assuming when you're publishing potentially copyrighted material. So for that reason, mechanisms like statutory licensing exist, where you don't necessarily, you can say that I conducted a diligent search to look for this person who may have claims over this, but I couldn't find them, and therefore, please give me a license to publish it anyway. The third kind of way in which archives can use this material exists through copyright limitations or exceptions made particularly for this purpose. And there are a number of copyright exceptions and exemptions within the Copyright Act of India. Many of you might have heard of a few landmark cases that came out some years ago, particularly the DU photocopy case, which said that when you're using any kind of copyrighted material in the context of classroom education, it's known as like the fair dealing exemption. So essentially, you're allowed to use certain parts of copyrighted work for the purpose of imparting education in the context of a classroom or in the context of any form of educational institute. There are fairly broad kind of exemptions that exist, which all bring to mind once again that copyright is a limited monopoly that tries to balance public access to knowledge and public access to records and the kind of important historical work that archives do with the rights of the person who actually may have some kind of moral or monetary or financial claim over that work. Now, these exemptions, I won't go into detail in them, but essentially for things like preservation, for research and private use, these exemptions are fairly broad, and they are fairly important to exploit for archives as well. So, libraries, for example, are allowed to make up to three copies of a work or make digital copies of a work in order to improve their preservation. Like I said, there's nothing specifically for archives here, but there's definitely strong cases to be made for these exemptions to be extended specifically or more deliberately to archives. So yeah, that's kind of the first first tranche of the law that I wanted to take you through, and we'll get back to data protection law in a bit. But I wanted to ask Anubha to share her experience, particularly working on copyright and archives in the context of the National Cultural Audiovisual Archives that she had worked on. Thank you.
Thanks, Divij. Thank you for a really good overview of the law. I will be briefly touching upon what Divij has already sort of mentioned, and then sort of connect that to our observations and findings back in 2017 when we had sort of visited 4 archives across the country trying to understand how they acquire materials and what their sense of copyright was, how their awareness of copyright law was, and their interactions with the law, if any. So Divij has already pointed out that there are different kinds of work. You have literary works, you have dramatic works, you have musical works, and artistic works that are recognized under the law. And these obviously have sort of attributes which sort of make them a literary work or a dramatic work. Apart from that, the law recognizes other kinds of works which have to do more in terms of the properties they have, in the sense as to who created it, and are the owners, or are the people who possess a particular sort of piece of work, do they have sort of the requisite permissions to provide licensing to use that work. So one of the things that we found was these archives, which are both public and private in nature, they hosted a great amount of sort of government works. They had a huge quantum of orphan works. They had works, which had underlying qualities of traditional cultural expressions. So, this is something that we encountered, apart from obviously the audiovisual nature of the works that we were looking at specifically under this project. So let me just take you over what it means for archives when they have such works in their possession, and how do you identify these works, and what are the sort of benefits or disadvantages that are posed when you have these works in your custody. So let me begin by looking at orphan works, something that Divij has already mentioned. Orphan works are basically works for which neither the owner nor the author is traceable, more so the owner. So the person who is interested in using the work, publishing the work, sharing the work, copying the work, does not know who to reach out to seek permissions to do these things with that specific work. And this is obviously a big challenge for archives, and this was noted to be a big challenge for the archives that we visited, especially archives that were, public institutions, because they had sort of like longer histories and sort of had been functioning in this space like that. So one of the biggest challenges was to provide them with advice that will help them sort of clear the rights and sort of be able to use that work. And then when we looked at the act to see what mechanism there was to help archivists sort of clear rights and sort of be able to use this work, we found out that the mechanism was fairly sort of unwieldy. Any person who is interested in using an orphan work, the Act expects that person to publish an advertisement in almost all sort of national newspapers in the country. So there is this need to sort of satisfy like a proper due diligence search by the person in respect of every work. And then once they have sort of met that condition, they're supposed to sort of apply to a judicial authority, of course, a judicial authority now, which is the Intellectual Property Appellate Board. They have to present their case. They have to convince the board that they did the due diligence, and then the board will decide the royalty and the terms of use and so on and so forth. So this is a lot of paperwork, and this is a lot of sort of legal work that any archive has to undertake. And I mean, it is clear from our sort of survey, it was clear that almost none of the archives have sort of taken advantage of this provision. And this is a very outdated mechanism, in fact, and it happens to exist in other copyright legislations in the world. For example, when it existed in Canada, and an empirical survey later showed that during the course of the existence of this mechanism, there were only about, I think, under 100 applications that were cleared. I think this provision existed for easily for about 2 to 3 decades. So the Western countries have been sort of progressive when it comes to sort of revising this mechanism. But here, in our experience, we realized that the conversation hasn't been begun looking at this dimension of the law. Then moving on to government works. So we realized that a lot of archives are obviously public institutions, which means that they are either autonomous bodies which are being set up under statutes. So there is sort of a clear flow of sort of control and direction exercised by the government when it comes to creation of works at these archives. And a lot of the archives were in fact art centers. So they were also engaged in sort of creating works. I mean, for example, if they were sort of organizing a performance and inviting artists to participate at a festival, which is one of the mandates for, most of these archives. So they were sort of very instrumental with doing that. And then we realized that there is this provision which exists in the Act that allows them to own the copyright of works which have been sort of commissioned by them. So for institutions which held like a heavy quantum of these kind of works, for them, the issue of clearing rights and, seeking permissions was significantly reduced. But again, it wasn't completely eliminated because the law clearly states that if it is a work that involves performers, you need to sort of get the clearance from the performers as well to be able to sort of publish these works. But just figuring out that, a lot of this is already owned by the institution, I think that was sort of like a good thing for them. Then the other thing that we noticed was a lot of the work that was sort of underlying these the collections. It was in the nature of traditional cultural expressions. So these are essentially works that have been recognized to be as expressions which are in the nature of sort of oral traditions that are captured on some medium, or for example, folk performances, or sort of elements that capture the culture of a certain milieu or a group or something of the sort. And the other characteristic of these sort of works is that it is not easy to attribute this to a single individual. It is not easy to attribute this to even a single group. It has been passed down over generations. It has been adapted and and taught and sort of published in various forms here and there. So this was the other challenge that a lot of these institutions had, because this sort of complicated how they could sort of go about getting permissions. This also brings into like a lot of ethical questions as to how do you sort of work with artists whose work has gone unrecognized for so long. And given that a lot of these archives were sort of collecting these works and organizing performances in good faith, they have sort of not at the beginning collected or taken permissions from every artist that was involved, and they just have sort of raw footage of it all, but they don't have the permission to sort of publish it. So these were the challenges that we saw, and then we had to sort of also prepare sort of a best practices guide as to how they should go about solving this sort of particular problem. The other aspect that I wanted to discuss is fair dealing and limitations and exceptions, but I think Divij has covered that to a great detail. The only thing I would add there is that in respect of, the particularities are discussed in respect of government works, orphan works. There are exceptions to using these kind of works in that particular section as well. So I encourage you all to go and take a look at the law. And if you have any questions, I'm happy to take them at the end of this discussion, or feel free to write to me. Thanks.
Thanks so much, Anubha. That's really interesting. And I think, there's so many things that need to be kept, that people need to be mindful of. There's been a few questions around, exemptions and fair dealing. But I think generally the kind of like, say, the algorithm which people would go through to consider whether something, how an archive should approach this is generally to first see whether this is, what kind of work it is, right? Because different kinds of copyright law will apply to different kinds of works, whether it's, is it a literary work? Is it dramatic? Is it a performance? That's one category. Is it published? Is it unpublished? That's another category. Is it a government work? Or is it, is it not a government work? Is it an orphan work, which means that you've conducted a diligence, the owner, or is it some other kind of work? Then you see whether, then you have to come that, because copyright has become so expansive, most things kind of tend to be presumptively copyrighted. And then you can move on to kind of then looking at if something is actually copyrighted, then what kind of exemptions possibly apply. And exemptions ought to be incredibly broadly interpreted. That's at least the law of India, that exemptions exist really as user rights and should be expansively interpreted. But they're still incredibly contextual. So, clinically, if I were to give advice, and please don't consider this as legal advice, but I would just say that it's important to document this process of thinking that every archive has when dealing with these kinds of works, right? What made you move ahead and kind of claim a particular exemption? What made you, how did you go about doing this diligent search for the author, or did you make any efforts to kind of start licensing that work from them? I think that's kind of important to, very generally when thinking about copyright law, to understand that people have different forms of claims over, or could potentially have different forms of claims over the records that you're talking about. And what have you done to satisfy the fact that you are working in the public interest, or you're working in a manner which satisfy these claims. The second thing I want to, and now we'll obviously carry on the discussion on copyright as well, but I also wanted to flag or go through a second category of the law, which will increasingly be relevant for archives, particularly given, the like movements that this space of law has been having in India for the last few years, which is data protection and privacy law. And of course, archives have dealt with restricted material. In the last session, we discussed things like healthcare records, right, and mental health records, which have tremendous implications for an individual's privacy. At the same time, of course, private records or personal information is often and in so many contexts important to share with the public, or in some restricted form, or important for historical preservation, or the general kind of purpose that archives tend to fulfill. Now, India has an upcoming personal data protection bill, right? It's been stalled a little bit, but maybe people can expect that it should be passed sometime this year, which is a fairly overarching and very broad law to deal with any kind of personal information about individuals. And given that you have that archives work with in records from correspondence to kind of personal to personal healthcare records, or any form of other kind of historical records dealing with specific individuals, these are going to be implicated the moment such a law passes. In fact, already to a large extent, I think under tortuous law, there is some kind of individuals already have various forms of privacy claims over records that other people, or over information that other people hold about them. So it's important to look at what this law specifically means, very broadly, because we don't have so much time about it. Very broadly, personal data protection law aims to give individuals about whom information pertains greater ownership, not ownership in the copyright sense, but greater control over how that information is shared with them, or what they can do with that information, right? So for example, if there's a particular letter about an individual pertaining to a real life, and maybe like not a deceased individual, so it's called a natural person under the law. If your correspondence holds personal information about a natural person, for example, their phone number, or something that they said to someone, or their personal attributes like their age, their sexuality, or any other kind of their health attributes, that's kind of covered under the scope of personal data protection law. And because simply by the fact that this person's information is included in a record, they have certain kinds of claims over that record. They can, for example, say that, you should have taken my consent before publishing this record, or should have taken my consent, before even collecting information about me and storing it in a particular kind of archive. They can also say that I want this information to be deleted from your archive because it pertains to me, it pertains to my personal information. So it's also important to note that there are tremendous implications of data protection law, which are forthcoming in India, which will implicate archives. There are also exemptions that have been made under the law for archives, which are not very clearly fleshed out. Now, in other jurisdictions like the UK or in the EU, which has the General Data Protection Regulation, there are more clear exemptions about how archives work in the public interest and what kind of how this work needs to be preserved when you're talking about data protection law and giving individuals claims, wide amounts of claims over personal data. But in India, we haven't really had this conversation so much, and I really hope people start thinking about this and contributing to it. So I just wanted, so Srinivas has worked quite extensively in archiving government records, in archiving kind of, records which have public importance. And often these records will contain private information which can be implicated under a right to privacy or under data protection law. So I wanted Srinivas to share his experience about how, as an archivist, as a digital archivist particularly, you think about, communicating this work and what kind of data protection, considerations do come up when you're doing this kind of archival practice.
Just want to have a time check before I go on. How long do I have?
15 minutes.
15 minutes, great. So I'm going to show you some public records. Screen sharing, actually, I thought I wouldn't. It's like it's better to show you some of these. I think it should be visible now. So I'm actually opened the archive.org where I tend to upload a lot of documents. And one of the collections that I have helped create along with Sushant Sinha and Carl Malamud at public.research.org was the Gazettes of India archive. This is where all of your laws, all of your Government of India acts, bills, all of them get published, right? But also, if you're trying to change your name, right? Legal names, you have to actually get your name published in Gazette. And so the Gazette is full of names of people who are trying to take a new name, and the only existence that they were someone else in a previous life is actually part of Gazettes. If one can explore these collections, you'll probably find lots of names. If you can just search them, you'll find a lot of these. The reason I bring it up is because when someone is trying to get a new name, he doesn't want to be identified with his whole name sometimes, legally, or even is trying to essentially get a new name because of his own past issues, his own life. But at the same time, while public records have a lot of these names, the other set of public records where people whose actual names appear a lot is the court records. So if you're part of any family disputes and you approach the court, your name is recorded part of the court documents, and court documents tend to publish it. Public archives like India Qanun, for example, publish these. And if you actually go to Indian Qanun, like some of these records could be available on Google. When somebody searches your name, these court records might actually appear. So, and these happen because most of the court websites actually don't allow you to index court documents, but public archives like India Qanun crawl these court documents and make it available to a lot of people to enable search across courts. And this essentially means if your name is part of a public record, it actually pops on Google search. Why is this important? Is because in the recent past, especially in the EU, someone actually filed a petition asking that his name be removed from the search engine Google because of a past crime he was convicted for, and he actually served his time, and he doesn't want it to be over Google anymore, and the European courts actually allowed it. And EU actually recognizes the whole idea of right to be forgotten for an individual, which I don't think the Indian law yet permits. But in terms of this is very contextual in case of newspapers and journalists. But at the same time, archives also tend to document a lot of these newspapers or magazines, right? So it's not just that they're available on Google, but they're also on physical copies which are available in archives. But the idea of this whole right to be forgotten in the context of right to privacy is only limited to search engines. It's not like the actual records need to be destroyed. So that way, archives are exempted in that. In case of laws, in particular, judgments where your details are in the public domain, there are actually clear laws. If one looks at the whole Rajgopal versus State of Tamil Nadu in 1994, it clearly says that public records do not get the whole right to privacy argument at some level. But again, this is a very old judgment. If one says that right to be forgotten needs to be given at some level, archives can be asked and especially if you're a digital archive, right? Like especially something like archive.org, which is publishing a lot of these records, you may be asked to actually remove them. But something like that could come up, but as of now, the whole idea of right to be forgotten does not exist. In terms of exemptions to the archives on privacy, there was a section that the Justice Sri Krishna committee actually recommended part of its draft bill. I don't think the current draft actually allows these exemptions. It's yet to be seen what the parliament does when we discuss this at length. But in terms of going back to the whole idea of public records, what are the best practices that archives can follow? India Kanun, for example, Sushant has been facing a lot of queries on this. He himself was involved in like the people sued him saying, why are you publishing my name with court records on your website? So they actually have a link where they tell you why these court records are public, why they publish it, why does India Kanun has access to it. It's not just India Kanun. India Kanun is one of the public archives, but there are a lot of private archives, right? Like everybody is trying to download court documents and is trying to create access for these for lawyers, for even judges or even other corporate clients. So in case of disputes, what do you do? They actually have a section, can you remove or modify my court case? In the past, India Kanun actually used to take a stance where they used to remove if you ask them, and they used to de-index a particular court record. But they have clearly said they will not remove the entire document. But in case of social issues like divorce, maintenance, child adoption, and child custodies, they have agreed to de-index these court records of India Kanun from search engines like Yahoo and Google. But these are again practices that India Kanun is adopting itself in compliance with existing Indian penal codes. And in case of the whole idea of family courts is because it's a personal matter. I think it's a decision which Sushant made because he was running India Kanun. But it's up to the practitioners at some level to adopt some of these issues, and it's one of the recommended practices. So going back to some of my own practice in terms of looking at CCTV footage, right? So I want to bring this up 1 second. Let's tab. Yeah. So part of this public recording process of digital archives, I've also been looking at CCTV footage. And the reason I bring this up is it's in the context of the election process. where the Election Commission actually installs CCTV cameras in polling booths, and one can actually go get these details uh, from the Election Commission. Like before 45 days after the election results are declared, one can file an RTI request and get this data. The reason I bring this up is because there are whole issues of facial recognition that are coming up in terms of CCTV context, and the Election Commission actually allows you to do this. And it, it's a public process. Technically speaking, all of this information needs to be public, and the Election Commission is doing that. And I've been trying to archive this. We haven't published it, and primarily because it has faces, and we don't want to allow people to have a huge collection of facial recognition information. You could look at some of these issues were a huge concern in the US, where US police were trying to bring body cameras, right? Like technically speaking, all CCTV cameras that are in public domain are public infrastructure, especially if the police is spending public money on it, and one can actually obtain the CCTV information. While they try to evade this by essentially deleting all the information under 30 days and essentially saying you that information was deleted. But there are ways to actually obtain some of these public information that one can look at. And it's not just about, say, CCTVs or the Election Commission, right? Like it's all forms of public records. If one goes more towards policing, the FIR records are now public. One can go to each state police CCTNS citizen portals, like the Telangana State Police Department, or even the Rajasthan's CCTNS portal, where one probably needs to log in and access this information. But we have been archiving these records, and if you look at something like an FIR, it has a lot of information, especially all the personal details of the individual who's complaining. In this case, it was actually the deputy director of UIDAI, and his phone numbers available.
Srinivas,
So
you have 1 minute. Sorry.
yeah, so I'm just going to end with the FIRs. So FIRs are like public records, just like court records, but one can't just publish all of them or index them in search engines or make them available for search engines like Google, right? So what if one has to maintain a private archive? These are deeply important documents, especially in the context of issues like gender offenses, rape, where you don't want a lot of this information to be stored. Technically, the IPC 228, the Indian Penal Code 228 Section A, actually refers to how the police needs to ensure when they're trying to document the details of victims, right? And it often in practice they don't follow it. I mean, there have been instances on India Canon itself where you would have judges actually including the names of rape victims, and that's against the law, and the judge would actually should be aware of it, but often they ignore it. So when it comes to practice, most of the government public documents have a lot of sensitive information, and a lot of it can't be made public. And but archives, in case of archiving, how do you do this? Then the only way to do is make private archives and give access controls to only select set of people. I mean, people. I archive this because I am trying to understand how crime patterns happen in a city, and these are being archived at a local library. We haven't announced this to anyone yet, but it's important that some of these things need to be happening to make our own organizations like the police departments accountable. And this kind of extends to other probably non-public documents. There have been discussions, I believe, in the queer community in Bangalore who have been trying to archive the queer movement in India, where in some of their leaders, right, when you're trying to archive a movement, there's a lot of personal information, not just about an individual, but also about a family. And there are questions that these families are now making, that how can you make details about my family public in your archive? So it's about an individual, but the individual has so many relationships. It's not like he's isolated. So which comes back to this whole case of what would you do in case of family cases like that, like what India Kanun has been doing.
Thanks, Srinivas.
Yeah. Sorry.
Just,
Yeah. So
30
I'll
seconds
just
to
end
wrap
it
up.
there.
Yeah.
I'll just end it there. I'm talking about mostly about what are the practical concerns, but legally most of these are in a limbo. I'm happy to answer more questions, but this is what I've been going through as a practitioner of archiving digital records.
Thank you. And that's really fascinating. And I think, one of the main lessons that kind of comes out to me, and something that everyone should be aware of, is that all of these laws, to a large extent, maybe not the upcoming personal data protection law, but copyright law definitely has been drafted for an analog age. And digitization and digital sharing, preservation, all of that completely shifts our ideas of how to make things accessible, how to publish things, what constitutes publication, and how to kind of restrict access, right? Even something as simple as, even like digitizing a document involves many stages of copying, or making, multiple reproductions which implicate copyright law. Similarly, kind of, making something online totally shifts ideas of what kind of data protection or privacy implications a record might have. And thanks to Srinivas, thanks for sharing your experience on that. I think there's been a few questions, and I think, yeah, it would be great if we can just move on to answering questions from the participants here. I'm just on the document. So there's been a question about, about copyleft and how to balance authorship claims and public access. I think Anubha can speak to that.
Sorry, can you read out the question for me, Divij? I did not see
So
it.
the question is, with respect to copyright laws framework of balance between authorship and public access, can one of the panelists talk about copyleft, and how does copyleft view these sometimes competing claims?
So copyleft is essentially a movement that was born out of the excessive privatization of, knowledge, that was observed in the early 2000. In fact, it goes back even earlier, but just in terms of putting a marker to when these movements began. I mean, you have the access to knowledge movement that started off in 2004. You have the open access movement that predated it, and copyleft has also often come up in context of free and open source code. Sure, I mean, it is a response to the excessive privatization of knowledge, to the excessive encumbrance of knowledge. I mean, people have pointed out that there are genuine grounds of public interest. There are genuine sort of socio-economic lens which exists, and putting rights and putting barriers to accessing knowledge needs to be seen from these angles as well. And I think that is sort of one of the fundamental principle underpinnings of the movement. Divij, feel free to add, and I'm sure Srinivas would also have more to share.
Thank you. I just wanted to add, yeah, so there are there's actually a few questions about fair dealing and fair use. So I just wanted to clarify a few of these concepts again. So the copyleft movement, and I think, the kind of Creative Commons has been one of the bigger proponents of this whole thing, is essentially a way to get around the fact that there's always presumptive copyright over everything, and therefore you need permissions for everything, right? So when you see, they've actually tactically used this idea to say that, and if I'm putting out content under Creative Commons or like a copyleft, what's known as a copyleft license, then I'm essentially making that information available for anyone to use with very few restrictions, with not the kind of permission system that we have under our Indian Copyright Act. So it's a way of kind of, like I said, because this is a voluntary kind of contractual a right that exists for authorship claims, it's a way of authors to give up their claims and to allow people to use this in various, for public interest or for private research or whatever it is. On the other hand, statutory exemptions are not contractual in nature. They can be utilized by everybody. And so there are some some
I think I
things
would
that are
disagree with you on that point. In the Indian context, it's not clear at all. So that which is fairly unfortunate.
That's fair. Yeah. But yeah, I mean, to essentially say that like the statutory exemptions at least have been clarified by courts to be kind of user rights that can be somewhat broadly interpreted. But there is a distinction between the US concept of fair use and the concepts of statutory exemptions in India, which need to be, because the fair use exemption is basically a judicial kind of pronouncement where you go into four very broad factors about how are you using it, how is it impacting the commercial, how is it impacting the original author and their claims. Whereas in India, you have to stick to the kind of statutory text under Section 52 primarily, right? Even though the concept of fair dealing does exist, and kind of import some concepts into from like US law or Canadian law primarily about fair use. We primarily for archives particularly, I think we need to look into other forms of exemptions which don't have that fair dealing language in it specifically. Although it does, of course, the concept of the use being fair filters into each of these provisions, but I wouldn't say that there's a specific fair use exemption under Indian law. It needs to be seen from a case to case basis of what specific exemption could apply to the work that you're doing or the kind of records that you're dealing with, right? Another question is about the Internet Archive, and I'll let Srinivas answer this. The question basically is about how do you use fair use or fair dealing when talking about open archives like the 858.ma. I'm not quite sure about that, but essentially something that functions as repositories of evidence for future court cases. So maybe Srinivas, you can speak about, once again to speak to kind of, this balancing of public interest and kind of copyright or authorship or privacy claims.
So the most important issue about any open archive is the material that you're trying to share, is it widely required by a large audience? Like when you look at Internet Archive, you have materials from software, radio, you have Ambedkar's and Gandhi's radio speeches, from everything from that to public records, right? Like it's a wide range of material, and they consider themselves between a library and archive. It depends on how old the material goes, right? If your materials beyond those, it has material from the 19th century, and some of the oldest documents of the world are on archive.org. And it's important for a lot of people who actually can't physically travel to different locations that this material suddenly becomes important. But in terms of, especially in the case of education, right? Like, let's not go into the idea of fair use and not, but clearly in India, if you look at the whole Delhi High Court case, we have clearly said for education, you can copy the material as many times as you want, especially if it's being distributed by a professor, right? So I would like to extend that to libraries, actually. One could say that libraries do perform these public roles when the material is of that kind. But in the recent case about archive, where publishers are suing archive, it's mostly about them distributing their books physically. It's about the national library that the Internet Archive has launched because of the lockdown, where people can't travel, where they're giving out a lot of their physical copies of books that they own. But in terms of this whole balancing act, I think it's a tug of war, right? The publishers will try to come, and so will be the people who are trying to archive, the archivists and the open knowledge folks. It will simply evolve over time, because it's primarily, again, because of the whole US Copyright Act, which has been extended so many times. The Mickey Mouse Act, because every time the Mickey Mouse would try to come out of copyright, they would extend it. I mean, this can't go on forever, right? So I think it's coming out. I mean, it expired. You have seen works like from 1923, the year from which the copyright law does not apply in the US now. Archive.org has been scanning a lot of those material and is now slowly uploading them. So people are waiting out for the copyright years to expire, and that's the only way to do it. You copy the material, but don't make it open until the copyright expires.
Thanks, Srinivas. Yeah, I think generally also there's also a few questions about like permissions, identities, and kind of maybe kind of how to think about data protection or privacy in the context of the law particularly, but also in the context of different kinds of materials that you're collecting. I think the fundamental thing that when you're going through this thought process of what kind of permissions do I need, at least in our data protection law or the forthcoming law, consent is like the prime factor that you need to consider, right? And again, that's kind of like considering the voluntariness of using somebody's information, ensuring that they know that you're using this information. That may not always be possible, and that's why certain kinds of exemptions exist. But speaking specifically to the question about about the trans community and how people, this like the permission that a donor may have given to use material may change after reassignment surgery. I think one of the principles of consent itself is that it must be informed and it must be continuing. And this is kind of also embodied within the Data Protection Act. So if you're relying upon consent, and you don't always have to rely upon consent to actually use some material, as Srinivas currently pointed out, there may be lots of public interests in publishing private records or private, things that would have data protection implications. If you're relying upon consent, then one of the things you need to talk about is also to talk about continuing consent, which means giving the individuals who have donated or about whom this information relates the ability to withdraw their consent at any point of time and stop the publication of that. Unless you can rely on some kind of public interest exemption that may exist under the law. For example, if you're a government agency which needs to collect this information and needs to give it to the public, or if you're a public interest archive which is relying upon a research and archiving exemption under the law, always keep in mind that you have to provide mechanisms for individuals to know that their information is being stored in this archive, and that to withdraw their consent if they believe it should not be stored. There's a fairly long question by Ritvika, and we'll just take 5 minutes more, or maybe like two more questions and then wrap up.
Divij, you can go up to maybe 145 or 150 since we started late as well. Or I mean, however long the audience wants to stay. So, yeah.
Sure. Is that fine with Srinivas?
Actually, from the panelists, I shouldn't. I mean, I'll leave it to you guys.
I'm okay to stay till 145. Is that okay with Srinivas and Anubha?
Yeah, I'm here.
Sure.
Sure. Okay, then we'll do that. Right. So, Ritika has spoken about visual materials and their copyright. Okay, so it's kind of about the kind of license or the kind of contract that should be signed between, or the kind of donor agreement that should be made when considering access to a work. And I think this is something that Anubha also spoke to. But just to reiterate, the kind of permissions that you, the kind of rights that copyright law generally gives you, right? It's a whole bundle of rights which encompasses the right to reproduce something, the right to show something to someone, or to make a copy and then distribute that copy. Right. Now, a normal, like one way in which this could be implicated, even in visual archives, is that if someone is coming to the archives to inspect a particular record, even if it's a visual, first of all, the visual record will presumptively be copyrighted as long as it's some kind of an original video work, right? Sometimes you will want to make a copy of that record in order to preserve it, or maybe to lend it. Now, if you start lending those records to individuals, that's implicating the distribution right. So when you sign a donor agreement with somebody, you need to ensure that, if you're relying upon the agreement and not relying upon an exemption to copyright per se, then you need to ensure that the donor agreement actually has provisions that say that we will be making copies of this work and lending it out to individuals for the purpose, and specify the purpose for which and the conditions under which you'll be lending them out. It will most likely be for private use or for private research, and therefore that needs to be mentioned. And kind of, you need to have some foresight into thinking about how individuals are likely to use this and in what context they're likely to use this. So yeah, to very basically answer your question, it's best to put in all of these conditions in the donor agreement itself to envisage the kind of use that researchers might have of maybe lending this work. And of course, in the context of digitizing this work, it becomes very, very different because in that case, you're both making multiple copies as well as distributing multiple copies and also making things available to the public at large. So there's three kinds of like rights within the bundle of rights that are generally implicated there. So yeah, the basic guidance would be to be as detailed as possible about the potential uses and the potential ways in which a record could be copied, used, or distributed, and to have all of that included within the donor agreement. And I hope that answers your question. And Anubha and Srinivas, if you have something to add.
Just that, I mean, this is something that we had also come across quite a bit on our field surveys. And often, while there was an agreement registering the transfer of the object or basically the artifact from the donor to the institution, but there was no concomitant sort of agreement registering the transfer of rights. So that was often seen to be missing, and there was also little awareness as to how necessary that was. And often donors might also not sort of be fully aware of the rights that they have in the material that they own. I mean, it might relate to a family member, but for example, if it's a photograph, it's a copyright ownership of the person who clicked it. So there are a lot of complexities involved, and just flagging of some other things that we came across in similar context. Thanks.
I think, yeah. So I think this is generally also like a policy issue that many countries and many jurisdictions have been dealing with. I'm sorry, I missed one part of your question, which is to say if somebody outside of your specific agreement has a claim, then your agreement will not cover it. So a contract is only between the parties who have contracted. So if there's a third party who says that I have an interest in this record or I have some copyright or privacy claim over some record, then you have to respond to that claim separately. And of course, this is a big problem, right? A number of countries have tried to resolve this by, for example, creating collective rights mechanisms, which I think is a good way to go forward with this, and something that India should also consider moving away from this. I don't know how many people on this call would have actually written to the government asking for a license to use an orphan work. And I know that, as Anubha said, the process is really cumbersome, and it seems like you can't even find the form to begin that process, right? So
I filed an RTI with the copyright department and they had no response to share, and this provision existed in our books since I think the 80s or the 90s.
Yeah, so it's really ridiculous. But so one way that some Nordic countries have dealt with similar issues is to create something called extended collective licensing, which basically means that if there's you create a body that is responsible for licensing all forms of unpublished orphan works, for example, and then everybody presumptively simply has to give some kind of a statutory notice to that body or some kind of minimal fee, and they can begin to use all works within that category. Now, how you define that category is important. It could be something as limited as saying unpublished audiovisual works. It could be something as broad as saying all orphan works, right? But the idea is to basically make the process for getting permission from people more smooth and to not to be as risk averse as possible. Yeah. Any other questions? I think just there is one other question which is about which is from Maya, which says, how can interview-based work done in educational institutions but put out publicly, such as in digital scholarship, be construed fair use? I'm not entirely sure. Let me just copy paste this question here. So is this about kind of like interview-based work? Do you mean, say, collecting oral histories?
Yeah, Divij, I can just speak it out actually.
Okay.
So the question was that, we have this understanding in educational spaces that more or less everything we use and all the kind of research we do is covered under some grand idea of fair use. I don't know specifically what we call it, but but the thing is, there are often there is primary data collection in the form of interview taking, and this also involves consent and sign-offs and such. So do they sort of stand an exception to this overall sense that just because it's in an educational space, it's allowed? Or is there also other sort of considerations that we should be looking at?
So I would firstly say that the educational exception that we've been talking about isn't as broad as maybe many people understand it. The specific exemption that was relied upon, particularly in the very famous DU photocopy case, was an exemption that was created for the purpose of classroom teaching specifically, right? Although it was broadly interpreted, it needs to be kept in mind that the language of that provision itself refers very specifically to classroom teaching. So even if you're interpreting it at the broadest possible level, that restriction needs to be kept in mind. So it's, I would say it's difficult to say that simply because of the virtue of what kind of institution you are that you can rely on this. Institutional exemptions to copyright aren't still very clear under the Indian copyright law. Like I said in the beginning, the law doesn't make very clear references to what constitutes a library, a museum, or an archive, and it doesn't really give specific grants of copyright depending on institution. It's more dependent on the purpose for which you're using a particular record. So if you're using it for research, if you're using it for private study, if you're using it for preservation, those are the kind of purposes that are generally protected under copyright exemption clauses. Similarly, there are limitations that are made for, like classrooms as an institution, libraries as an institution. But ultimately, I would say, it really depends on the specific language of the exemption that you're relying upon. And there's no, I would be very wary of saying that there's a general kind of fair use that can be made in the context of any kind of work being done in an educational institute.
Thank you.
Anubha, Srinivas, anything to add there?
I agree with you, Divij, largely. And yeah, I mean, it also sort of depends on, if the education is commissioning the recording of the interviews, I would imagine that the institution is ordinarily owner of the copyright. And then after that, I think you really don't need to get the rights cleared by anyone else except for the interviewees themselves, who should just consent to sort of, who should just agree to this sort of a publication happening. That's what my sense would be under ordinary circumstances.
Yeah, and once again, to see whether something, if someone is just relaying some facts, if someone in an interview is simply talking about what happened in their day, right? I would be wary of even saying that that's copyrighted. Although I know like it's fairly complicated and there's no clear metric to really define what constitutes an original content. But generally the relaying of facts, for example, one of the landmark cases to say that, copying of a phone book isn't copyright infringement. Even if you put in a lot of effort into actually doing it, simply getting information together and relaying it without any kind of creativity involved in it wouldn't be something that infringes copyright. So I would encourage the use of a rule of thumb. Unfortunately, neither our courts nor any kind of our government institutions have provided clear guidance, which is really unfortunate, and which is something, all of us, I think, are working towards, like Srinivas, Anubha, and myself are kind of looking into how this practice can be, improved. And just to sign off, and I think we're, running on kind of overtime here, and I think we've answered most of the questions as well. I hope the output, or what you, all the participants here would take away particularly, is the need for, archivists to be more involved in the kind of public policy considerations that we have in dealing with the law. Because as you would have seen by now, most of the answers to your questions are that it really depends and there's no clarity. And if there's no clarity, then there's always that kind of little bit of risks that archives face. Should I use this or should I not use this? And because like these are so many of you are working in non-profit institutions which maybe don't have enormous amounts of resources, any kind of legal risk or any kind of financial risk is a big burden and could possibly disincentivize you from doing the important work that you do. So I would say that I would strongly encourage thinking about how the law needs to accommodate the needs of archives more clearly, more specifically, to indicate the kind of public interest work that's happening at these archives and why it's important, how it implicates privacy, data protection, as well as kind of claims of authorship and ownership, and how you respond to it. And maybe, working as kind of people at the crux of thinking about the things that you do, as well as, at the intersection of like building and developing these policies and laws. Perhaps, I really hope that we can incorporate these going forward into our laws and into our practices. So yeah, thank you so much. I hope it was a lot to cover, 2 fields of law within an hour-and-a-half session. But I hope that we managed to answer at least some of your questions and your queries about how this applies and how it affects your work. Thank you so much to thank you so much to Anubha and Srinivas for joining us and sharing your experience. It was really great and really interesting really great to know that, like there are people who are considering this in depth and carefully, and whose work I think will be really, really important going forward, thinking about the law and thinking about archives. That's all from me.
Thanks so much, Srinivas. Thank you, Divij. Thank you, Anubha. This is, I hope, a start to a much greater conversation that, I think we're all really in need of. So we might invite you back, to answer more queries that are difficult and challenging. But really appreciate it. Yeah, really, it was a great session, and apologies for all the inconveniences to everyone.
No, that's
See, yeah.
no one
See
problem.
you.
Thank you.
Thank you.
Bye.
Bye. Bye.